SwayamPrabha. Digital India. Educated India.
Good morning viewers, this is Dr. Ashwini Sival. I am here to speak on a very interesting topic in the series called Law, Science and Technology. Viewers, this series will entail lot of interesting topics and lot of interesting lectures, wherein I will cover almost all the advanced technologies and the legalities relating to those technologies. The outline of this series basically pertains to cover almost all the developed technologies or developing technologies and the legal issues surrounding those technologies. For instance, we will talk about law and AI, we will talk about augmented reality and law relating to it. We will also talk about virtual reality and law relating to it. We will also have a discussion on electronic revolution and dilemmas of legal control. We will also discuss nanotech and law. We will also discuss intellectual property and law. So, this series focuses on the scientific and technological feats and developments and the legal issues surrounding those developments. My dear viewers, this is a series which is one of its kind, or I will say that this is a series which is going to throw excellent discussions or open up excellent discussions on some of the interesting or untreaded areas of law. There are couple of areas where there are no legislations, regulations or no legal frameworks available. So, in those areas we will try to see as to what can be done and what kind of a legal framework may be evolved or may be created. So, in today's discussion I will primarily introduce you to the philosophy and policy of law, science and technology. We will go into the contours of law, science and technology, understand the intersection of law, science and technology, how these are intertwined and at what level they are intertwined. And specifically I will see the response of one field of study vis-a-vis to other field of study and vice versa, like we will see the response of law towards the science and tech and the response of science and tech towards the law, and what is their amalgamation and if there is any amalgamation or not, because some argue that these are two different fields wherein law pertains to or basically focuses on the process, and the process of law is very cumbersome, is delayed, is very lethargic. On the contrary, scientific feats and developments are focused more on the progress, not on the process, and there are instances where we can see that scientific developments or some scientific feats, they are offshoot of serendipity, or you may say they just occur serendipitously, but the law on the other hand can never occur serendipitously. Law has been the offshoot of, you may say, civilizations have developed the law, or probably laws were made by referring to the different customs prevailing into different societies and civilizations. So, law is not serendipitous. Technology at times may be serendipitous, but not always. Technology is also planned, and lot of research and development is done when any technology takes place, or it is invented or it is brought to fore. So, this kind of a discussion we will have during this lecture today, and this is the first lecture of this series which will open up or introduce you to the policy framework, the you may say philosophical framework of law, science and technology. Later on in the ensuing lectures of this series, as I told you earlier, that we will discuss or cater to the specific technological developments and the laws relating to those technological developments. So, when it comes to defining the relationship of law or technology, then it is a very difficult task, and there cannot be a very straightjacket or any straightjacket definition of law and technology or their intersection or their interface. It is genuinely a complex issue, and law has had a very troubled relationship with the science, because lawyers has never been domain experts of the science. So, in the realm of law, science has been defined either wrongly, or it has been misinterpreted, or it has been applied wrongly, and because of which at times it is seen that the amateur people who does not have the domain expertise into the scientific domains, they in the courtrooms in India as well as in other jurisdictions, they apply the scientific principles to come to the conclusions of law trials. So, which leads to a failure, ultimately the failure into the justice delivery system. So, how to balance or how to strike a balance between these things or between these complex issue is a very Herculean task, and lot of philosophers and scholars have propounded their own opinions and have discussed opined their own thoughts on it, but none seems very convincing, because this is a field which can never go parallel to each other. Law is always behind, or the science and technology or the developments pertaining to science and technology are always ahead of the law, because law making, as I said, is a cumbersome process. It requires parliamentarians to deliberate, to brainstorm, and then finally to come up after so many of discussions and hurdles, and at times there are some sort of political social hurdles which a law making or a process of law making faces. But on the contrary, the scientific work is something which is personal of a scientist or of a community that is a scientific community, and there rarely occurs any kind of such hurdle or hurdles which we face in the law making. And moreover, these days it is seen that the technological developments or their shelf life is too less. So, specifically in the cases of softwares, or in the cases of computer related inventions where the life of the technology is not long. So, the lawmakers are perplexed, because by the time they think of making any law, or they think of bringing any law pertaining to that particular discipline or that particular scientific innovation or computer related innovation, the particular scientific innovation or computer related innovation becomes obsolete, and most of the times it is seen that the same brings lot of ramifications, unknown ramifications, unregulated and unknown ramifications, which a law could not cater, because by the time the scientific innovation brought its consequences or ramifications, the law could not be made, and law's pace cannot cope up with the scientific developments or scientific consequences. Sometimes it is argued that it is other way around, where science it does not lead, rather it is always behind the law, and we see in the legislative law making or in the law making process that sometimes ex ante or ex post laws are made, which is at times very efficacious, or which addresses the concerns posed by the scientific innovations or the technological innovations. So, this is what we are trying to cover today, my dear viewers. So, with this brief introduction, I would like to show you some definitions proposed or tried to be proposed or give by some of the law scholars as well as scientists to the interface of law, science and technology. So, if you look at the kind of literature that is available and the arguments that are available, the law has had a long and troubled relationship with science. The misuse of science within the legal realm, as well as our failed attempts to make law more scientific as well as documented, and though the cause of these problems are not clear. So, law cannot be scientific. Law is law's origin is societal. Law's origin is basically from the society, not in a scientific way, because law has no doctrinal structures and no ultimate questions. In science there are doctrinal structures and ultimate questions to be answered or addressed, but in law most of the times it is seen that there prevails the discretion, and lot of things are based on equity and good conscience. So, in the case of science there is nothing which is based on equity and good conscience, but here a lot of things are based on equity and good conscience. So, some would argue that problems at the intersection of law and science, they flow from the changing nature of science, as I am arguing right now that science is going leaps and bounds or progressing leaps and bounds, but it may not be true always. Some may also argue that law is too slow to adapt to the changing developments or information available through the advancements of the science. It is partially true that law is definitely not too fast to adapt to the changing information through the scientific developments, but it can still answer some of the questions, or it can still address some of the issues, because laws may be futuristic, laws may be made keeping in mind what may be the tomorrow's scientific developments, but it is again I said earlier as well, and I am reiterating, it is not necessarily true, or it cannot be the absolute rule, and the reason being that scientific developments are multifarious and manifold, and you never know what kind of a challenge it may bring in, or it may pose. It may have some evil consequences or good consequences which lawmakers could not foresee or can never foresee. So, law is really too slow in certain cases, but it may be proactive, or it may be at times may be legislated proactively by the lawmakers to address the concerns of those futuristic developments in the law, in the science and technology, which are foreseeable, and at times it is also argued that delay in legal system is certainly a problem when law and science interact. But in my view, however, the deepest problem flow not from the changing nature of science, but from the changing nature of law. Law has over the period of time, or laws over the period of time has also changed. Their structure or their framework has also changed, which is why it is seen that the interaction of law and science at times faces lot of problem, and the best instance to understand or the change in the nature of the law is by referring to the laws pertaining to say for example a law which is made in 20 years time by the lawmakers, and a lot of many countries like us having good instances to clarify, or to you may say to manifest this particular problem, that our bill is tabled in the parliament in the year 2000, and yet it has not been passed. So, at times the changing nature of law is also a problem, and there is no constitutional mandate in the constitution, which is considered as a grand norm in the country, to make a law in a particular time frame, and political parties keeps on coming and changing, but they generally they do not give the priority to such things, and there is no constitutional mandate on them to make a particular law in a particular time frame. So, changing nature of law is also a problem. The another instance to understand the changing nature of law it's these days it is a blend of lot of disciplines. It is interdisciplinary. It is no more pure law. There are a lot of legislations like Information Technology Act, Intellectual Property Act, even the jurisprudence pertaining these kind of emerging laws or these kind of laws which are a blend of not just pure law, rather lot of disciplines. They can't be legislated easily because the parliamentarians are at times are clueless and they are not the domain experts of those fields. So they faced lot of challenges in creating the laws on time to tackle or cater or address the issues brought on by the technological feats or technological developments. So law is by nature evolutionary and adaptive, but as I said that there are no ultimate questions and no doctrinal structures in law. So that is why it yet takes time, or it still takes time in articulation and finally in understanding or comprehending the issues or challenges posed by the new technological development. So this changing nature of law also is one of the prominent problems or factors of a problem when it comes to the intersection of law and technology, right. Now moving ahead, when it comes to some more light on this aspect, let me tell you that law's definition of science is fairly uncluttered, and this can be easily understood by looking at the court's definition of science as the process by which knowledge is systematized or classified through the use of observation, experimentation or reasoning. Courts have defined the science as a process by which the knowledge is systematized or classified, and in this definition it is implicit that science is cumulative and progressive. As I told you that science focuses on the progress, but laws focuses more on the process. Also implicit in law's definition of science is a veneration of or reverence of those things which are scientific, and then separation from those things that are not scientific. Science is something of value in which we can have confidence, but it is not the only thing, and law's definition of science most of the times it is observed that they revere the scientific things vis-a-vis to the non-scientific things. Although science conclusions may be speculative, provisional and subject to modification, science is ordinarily seen as a set apart from all other social activities by virtue of its institutionalized procedures for overcoming particularity and context dependence and its capacity for generating claims of universal validity. So definitely science is speculative, provisional and subject to modification, but it is considered something separate, distinctive than other social activities because it has institutionalized procedures. On the other hand, law basically is a social activity, or law's origin is social, or problems of the society, but science on the other hand depends largely on institutionalized procedures, right, for overcoming some problems or some long felt need or some providing for some solutions, etc. When we go to the historic perspective on law and science, we find that science the way it exists today did not existed or did not exist prior to the scientific revolution. It was only after the scientific revolution in Europe in the 1500s and 1600s it took the shape that it in the way it exists today. And the opening of this period in Europe, the term philosophy was still used to describe both things that we could consider philosophy and things that we could consider science. So nowadays philosophy is totally different discipline, or you may say a different perspective than the science, but at that point in time in the 1500s and 1600s it was umbrella term or umbrella discipline which included the philosophy or social things as well as the science in it. Not only were science and philosophy intertwined, all intellectual inquiry was intertwined with and considered subordinate to the theology of Christian church at that point in time. So, by the late 1600s, if you look at the further developments, Gottfried argued that law should be based on natural sciences such as geometry. So, viewers, is not it fascinating that a scholar in the 1600s in Europe arguing that law should be based on natural sciences such as geometry. So, he created a legal code based on scientific principles intended for adoption throughout the Austro-Hungarian Empire and Europe, although he was unsuccessful in convincing the Emperor Leopold I to enact the code. But his idea of enacting the law on the basis of sciences like geometry is a unique, and I do not know how visceral this idea was, because it looks abstract. It is not possible to have a law in such a in such a way based solely on the natural science like geometry. It is not that easy or imaginable to have a law made or created on the basis of geometry, but he created a legal code on scientific principles and on scientific methods, though he could not convince the emperor. What he saw in science was more than simply a way of organizing and synthesizing analysis. He saw the possibility of a systematic way of knowing the world and proceeding out of divine and rational first principles. The legal system would operate with an abstract purpose which could be expressed in elemental and reliable theorems. The theorems could be applied to calculate all potential case combinations, allowing legislators to determine all proper outcomes in advance. In this way, law could follow the insights of science of the time as it was emerging in a form separate from philosophy and theology. It is interesting to see scholar's perspective in the 1600s, wherein he is or he tried to develop the law based on the natural science, and with the abstract purpose which could be expressed in elemental and reliable theorems. But as I said, that law cannot be abstract, it is societal, it is living, it is dynamic. It can never be abstract. It is not possible to have an abstract law. Whichever law you see is abstract in nature, it is either inefficient or it is bound to be repealed or eliminated, because it cannot serve the purpose in a society unless it is dynamic, unless it is living, unless it is visceral in sense. So, when it comes to the definition of this intersection of law, science and technology, there have been couple of attempts made by some of the scholars to define law, science and technology and the intertwining or interface or intersection of these fields. It has been defined as the discipline that deals with how our legal system can and must adjust to accommodate the problems created by the ever more urgent and ubiquitous impact of technology on society. Wessel in 1989, he defined law, science and technology as the discipline that deals with how our legal system. So, here he is zeroing on the legal system or making legal system as the starting point of his discussion or his opinion, and he says that adjustment in the legal system to accommodate the problems created by ever more urgent and ubiquitous impact of technology on society is the relation of these two things, or is the relation of both. I won't agree fully on this aspect with him, because why to make the law as the starting point or the base? Why can't the science adjust with the law as created by the lawmakers? But it might not be liked by many who are of the opinion or who advocate for the development of scientific temper, and who advocate for the development of science and technology. And naturally I also to certain extent agree with them on this point, but regulating a science becomes a very challenging task post ante, when it has been already created, or when a scientific work has already been created. So, that remains just reactive. I mean, the law in that case remains purely reactive, it is not proactive, and reactive laws may not be that efficient, because by that time the particular scientific innovation or invention has led to some havoc, or has led to some sort of harm or injury, or some consequences or ramifications into the society. But we do try to regulate it post the ramifications, or post all the consequences. So why to make the legal discipline as the starting point instead of the science as the starting point, where science should not go beyond what the law has legislated, or what the law has been made in relation to a particular science. But in both the cases there may be different opinions and agreements and disagreements on this point. So now coming or going ahead with the definition propounded later on, the idea is to determine how the various processes of law, primarily judicial and legislative, respond to changes brought about by scientific advances. So this is what Green in 1990 said, that when it comes to law, science and technology, their relationship basically is to determine how various processes of law, the judicial, the legislative process, how they respond to changes brought about by the scientific advances. And we see that the laws predominantly are proactive, are not reactive, are reactive and are not proactive, I pardon my language. So this is something problematic, and which is why the scientific developments are leading to some consequences which are you may say harmful to the society as a whole. So the field of law, science and technology is premised on the belief that science is a distinctive institution worthy of distinctive treatment by lawyers. This is what Goldberg in 1986 said and premised. But lawyers mostly they do not know the science, and in the modern day courtroom you see that scientific methodologies or lot of scientific works or scientific feats are discussed, used, applied, but the lawyers or for that matter the judges or the lawmakers, they are not equipped to they are not equipped to apply those particular scientific knowledge to the courtroom, but yet they are applied and leading to at times to the jeopardy of the end user, or you may say the jeopardy of the litigant in that case, because court's end user is the litigant. Despite increased awareness in the field of science and technology, it poses unique issues for the law because of the different formulations that exist for examining law, science and technology. Here we will divide it into three primary strands. The first concerns the role of law in managing the impacts of science and technology. So this slide basically is to explain to you how or in what possible ways the intersection of law, science and technologies may be demarcated or classified. So it may be divided into three primary strands, or their their coexistence, or you may say their intersection may be divided into three strands, where the first is the role of the law in managing the impacts of science and technology, including risks or promoting the benefits and addressing ethical implications. So when we talk about this role of law, we have many examples which you may take, where law plays a very active role in managing the risks or promoting the benefits. When it comes to risks, we all know that there lies a lot of risk of losing your personal information, your sensitive information while using these information technology networks or systems. So here we have a lot of laws which caters like IT law or Digital Data Protection Act, etc. So this is the law's role, wherein it manages the risks, But as I said earlier that these are reactive mostly, because these laws came later. The scientific development took place decades ago, but the laws have been finalized and have come into effect of late. Then promoting the benefits, we know that these days the information communication technology is used for promoting lot of benefits in the governance, e-governance model. So where the IT Act again or such laws, they play a crucial or a critical role in promoting the benefits to the beneficiaries of the technological developments, etc. And then addressing ethical implications. Law also plays a crucial role in addressing the ethical implications, say for example in clinical trials, in drug approvals, or in bioethics, etc. We see the regulations, laws, bylaws, which cater or which addresses these issues, or the law plays a very efficient role here. The second concern basically pertains to the institutions of law and science, examining how law affects the practice of scientific research, as well as the reciprocal relationship of how science and technology influence the law. So in this second strand, you see that where the institutions of law and science, they examine how law affects the practice of scientific research. Here we understand how law affects the practice of scientific research. Law plays a very crucial role when it comes to scientific research, because in many jurisdictions including India, there are couple of laws which are restrictive to some scientific research. For the sake of example, I will tell you that patent as an intellectual property cannot be conferred on the innovations which are based on nuclear technology, but there may be lot of innovations which are based on atomic energy or nuclear energy, but yet there is no patent available to such scientific innovations. The reason being, the law or which law or the regulations which restricts it, or which restricts such practice of the science, right, as well as reciprocal relationship, where we see how science and technology influence the law. Well, it is again comprehensible that science and technology also affects the law, the way law affects it. The example to understand how science and technology influences the law, as I said, that post ante, or you may say post the development of a particular technology, the laws are made. So broadly those laws are based on or premised on addressing the concerns posed by the science and technology, or the scientific and technological development in question or in the context, and the law in that case remains restricted, you may say, to or it remains singular to a particular scientific innovation for which it is made, or for catering the issues and concerns of that particular context or that particular field. The third strand involves a mere a third strand involves more generic. The third strand involves more generic inquiry into the problems and tensions that arise from the intersection of law with science and technology. And this third strand where basically it is generic in nature, and its role is to inquire the problems and tensions that arise from the intersection. This is where there are no straight answers or no straight questions, and there are no straight jacket solutions available, because this is about the inquiring of a problem that occurs because of the intersection of two. And I am reminded of that Frankenstein monsters myth, wherein the scientist creates the monster, and then the monster who is the offshoot or is the product of the scientist is learning things, and at the end of the day the monster does not relinquish his monstrous nature and kills the scientist. So this is very problematic, that the confluence of two does not lead to you may say does not, it leads to prosperity, but does not lead to you may say that simplistic simplistic solutions or simplistic answers of their confluence or their intersection, and which is why we are more keen to understand their relationship, and this is an ongoing and evolving process. So, what role law plays in managing the impact of science and technology? Its role is as a tool that society has to tame and channel science and technology. As per Markey in 84, he says that law's role is to regulate or channel science and technology. The impacts of science and technology that law seeks to manage can be subdivided into risks, benefits and ethical implications, which we discussed earlier. Then coming to the second strand, controlling risk of new technologies. So, here we see that most of the times ex ante or before the risks are imposed, the laws and regulations are made or created. New and existing technologies create many known and potential health, safety, environmental and socio-economic risks. Law is the principal societal institution for controlling these risks through legislature, regulations and judiciary. In developing such controls, the role relies on science to assess the relevant risks. Risk regulation thus involves two levels of science law interaction: the role of law in regulating risks from science and technology, and the use of science by law to assess risk from new and existing technologies. Legislation and regulation seek to address and reduce risks ex ante, that is before the risks are imposed. So, the new technologies are controlled at times by the law ex ante, where the legislations or the regulations or for that matter the judiciary propounded norms are given beforehand for channelizing the science and technology or the feats in science and technology. Ex ante legislation and regulation are basically they are the statutory things or agencies statutorily empowered to do so presupposes the capability of adequately predict potential harms, are challenging undertaking for most risks. So, this is rare. Ex ante legislation and regulation in the field of law, science and technology is rare, or in the field of science and technology is rare, because no lawmaker or parliamentarian can foresee the offshoots or the consequences and the ramifications of the technologies, because in many technologies their consequences, their pros and cons are not known, and it is known that their risks and benefits are unknown. So, it is a known unknown, I call it a known unknown, right. It is a known unknown. We know that there are risks associated which you do not know, the human does not know. So, how can ex ante legislation or a regulation be made for such known unknown, right. Ex ante legislation or regulations may be made only for the known things or for the tried and tested things, not for the unknown things. And in the case of technology, or the risks imposed or the benefits promised or assured by the technologies are known unknown. Indeed, much of the complexity and controversies ex ante risk regulation relates to uncertainties in the identification and quantification of potential risks. Nevertheless, the ex ante risk and ex ante regulations proposes preventive measures, and they give a lot of beforehand assumptions, or they are based on forehand assumptions or speculations, not based on substantial evidence, or there are rarely substantial evidences in those cases. One ongoing tension in ex ante regulation is the respective roles of legislators and regulators. The legislature in most jurisdictions has plenary power and typically delegates to regulatory agencies the authority to regulate, subject to substantive and procedural requirements included in the legislation. And the ex ante regulation is basically always based on assumptions or some speculations or some you may say in the cases of scientific developments on the basis of not so much substantive evidences, because of which it are these ex ante regulations or ex ante legislations are not so great, and it has been seen that they are repealed or they are turning to be draconian or restrictive in their sweep and approach when it comes to the application of the scientific developments, as well as for the application of the particular scientific innovation. So, this is something about the ex ante and then when we talk about ex post, but ex post has a fundamental or inherent issue that it comes later when the technology has already been brought to fore and it has already caused some ramifications, some good and some bad to the society. So, ex post or even ex ante both has their limitations. Ex ante lacks foreseeability, it is based on assumptions, it is based on surmises. Ex post is basically something which does not categorically comes on time, or which does not specifically comes on time when it is really needed. It comes late or it at times delayed by decades. By that time the technology is no more in vogue or it loses its relevance. So, unlike ex ante regulation that evaluates whether a particular product, process or technology may present risks, ex post regulation is directed more specifically at whether the technology caused a specific type of injury in a particular individual or a group of individuals, because it is post ante. The scientific obstacles and uncertainties in demonstrating specific causation are even more complex than those faced in demonstrating general causation in the regulatory context. The judicial system uses presumptions, burden of proof and standard of proof in reaching decisions under conditions of uncertainty. So, post ante or ex post litigation and liability on the basis of ex post legislation or regulation is not considered again you may say very coherent or again not considered very efficacious, as in the same way the way ex ante is not considered very efficacious. So, this dilemma or conundrum in the cases of the third strand of this intersection, that is law, science and technology, is making it more complex and challenging. When it comes to promoting the benefits of new technologies, there are a couple of laws, for instance I have deliberately included into my presentation, like intellectual property, antitrust. These laws are basically made to promote the new technologies, and if you see the nature of these laws are not always neither ex ante nor ex post, nor ex post. These laws are in between somewhere, neither ex ante nor ex post, but they are yet relevant, like intellectual property law, which gives inventors and creators a limited temporal-spatial monopoly, or I mean the monopoly which is limited in terms of time and space. That kind of a legislation or set of laws are helping the inventors to get the monopoly rights and to exclusively commercially exploit their works, and the underlying rationale for protecting intellectual properties to promote innovation and to promote scientific temper, which I was talking about initially. So, such laws are also here for instance which foster innovation and promote the development of new technologies through several legal mechanisms and doctrines, and they are neither ex ante nor ex post strictly in nature, they are rather a blend of both. In addition, there are laws which encourage advances in technology through antitrust regime, I mean which promotes innovation by preventing companies from exercising monopoly power or colluding together to block new market entrants and innovators. So, we have such laws also which help the scientific innovators or technological innovators to have a equitable market wherein they can also exploit their or commercialize their intellectual properties or other kind of properties. And antitrust laws thwart the misuse of the market by the dominant players. It also thwarts anti-competitive agreements, or it also restricts, you may say, such bad combinations of the market players, which leads to adverse effect to the market, or which leads to adverse effect on the competition in the market or in the relevant market. So, we have such instruments for promoting innovation and advancing technologies. The government funding is also there in the scientific research and development, as well as indirect subsidization is there through legal mechanisms such as research and development tax credits. So, law plays an important role here again, where taxation laws are giving tax credits and subsidies, etc., and important stimulants for promoting research and science. Technology forcing regulations such as motor vehicle emission standards, prompt technological progress in specific industries are also in place, right, and other standards that provide for uniformity of new technology formats such as digital television likewise are intended to facilitate technological developments. So, law is not just restrictive, law is rather facilitating as well as promotional in nature. Then it also addresses ethical implications of technology. The law is the primary vehicle by which society seeks to resolve controversy raised by scientific research and new technologies, or you may say the regulations are those primary vehicles, or laws are those primary vehicles which seeks to address the concerns or ethical concerns created by scientific research. The bioethicist Daniel Challan has described this tendency to translate moral problems into legal problems as legalism, but he himself identifies a vacuum of societal institutions other than the law to resolve moral issues in a satisfactory manner. His idea is that law is not the only or sole discipline to you may say to satisfactorily solve the problem. Rather there are other societal institutions also, and he has identified those societal institutions other than law which may resolve moral issues in a satisfactory manner. Indeed, the failure to legally proscribe an activity carries an implicit message that the activity is morally acceptable. So, ethical concerns or ethical issues in the technologies are also addressed by the law. There are a lot of effects of science and technology on the practice of law, which I was talking about initially, and our courtrooms are these days using lot of scientific and technological innovations in determining or in practicing the law. The lawyers, the judges, the litigants, and even courtrooms are these days using those scientific technologies. We all have had we all have witnessed the virtualization of the courts during the COVID times, and it worked very effectively. It saved a lot of resources and time, and during that period because of the scientific development of our information communication technology and its prevalence or its ubiquity, not only the resources were saved, rather the disposal of the cases was speedier and swifter, and a lot of pending litigation got you may say cleared during that period of time. So, scientific and technological advances have both substantive and procedural effects. On substantive side, when it comes to substantive, new scientific evidence and techniques can change the way legal claims are resolved, including their outcomes. So, we all know that these days evidencing and techniques of evidences have changed drastically. There are electronic ways to put the evidences or to lead the or reduce the evidences in the courtrooms, and legal claims can be easily resolved by relying on those evidences. Though I would also like to point out that the tweaking and tinkering of the electronic evidences is much easier and much rampant in comparison with the tweaking or tinkering with the physical evidences. So, for example, forensic DNA evidence has fundamentally changed criminal law and paternity disputes by greatly improving the veracity of legal fact finding, while creating a plethora of new legal, ethical and social issues. So, we all witnessed that DNA science has improved to an extent where paternity disputes may be resolved with very great efficacy and veracity, and it has become much easier now to determine the paternity, but it has created a lot of social issues which did not exist earlier. Then advances in technology are further revolutionizing the procedural aspects of law. So, though the earlier slide covered the substantive aspects, it is going to talk about the procedural aspects of law. The practice of law has historically been influenced by new technologies, including the printing, telephone, photocopier, fax, now forensics or AI, now forensics and AI both, which never existed earlier. In the early 21st century, digital evidence has improved the quality and availability of trial evidence, while raising concerns about tampering with digital photos and recordings. So, I told you that digital evidences or in the cases of digital evidences, the tampering, tweaking is much easier and rampant. Online databases, digital document repositories, electronic discovery, new graphics and presentation technologies and digital courtrooms are changing the ways lawyers research, prepare and present their argument. So, this is how specifically the courtroom has become a new ball game, or you may say has become a new kind of a technology laden space where presentations, where documentations, where electronic evidences are led and the lawyers are doing their research and preparing and presenting their arguments with the help of the technologies these days, including the ICT, ranging from ICT to AI. These days AI is also used in the courtrooms by the lawyers and by the judges as well as the litigants to understand or to litigate their matter. Online filing and availability of court records is increasing the convenience and availability of judicial proceedings, yet creating new privacy concerns. So, on a procedural front, science and technology has assured the availability of the court records at any point of time. Now, the court records are not to be discarded or are not to be disposed of like the previous times when a lot of documentation used to happen and those documents were to be discarded or were to be destroyed, but electronic copies of things and online filing etc. has improved the procedural aspect of law in a very significant way, yet it has caused privacy concerns, for which again we have law, or answer lies in law for the privacy concerns, wherein we have the IT Act and then the Digital Data Protection Act etc. to cater to those aspects. When it comes to effects of law on the practice of science, law affects science and technology, individuals who have been aggrieved by scientific misconduct and it tries to seek judicial remedies. Advocates have even served non-party subpoenas on scientists who are doing research potentially pertinent to the lawsuit. So, this is one problematic scenario where law impacts the practice of science to some extent, where there are instances that lawyers are serving notices to the scientists for doing some potential research and stopping their work because of some ethical or some societal considerations or ramifications. Legislature also subjects scientists to new legal requirements. For example, when any scientific project is based on government funding, then it is important to take required legal steps to ensure absolute protection of the scientist and the general public, which delays the process or which delays the progress basically of the science, and science focuses more on the progress. In year 2000, the US Congress enacted the Data Quality Act, which imposes a series of substantive and procedural requirements on scientific methodology. These developments indicate a trend of growing legal intrusion on science and technology. It is called a great legal intrusion. Definitely it is an intrusion, but regulating the science and technology is also important by imposing some substantive and procedural requirements. Otherwise it will go haywire, or it will be haphazard, and it shall be uncontrollable. So, to have some control on the scientific research or scientific developments, or on growing science and technology, we need to have some procedural and substantive requirements in place for the scientists to follow, for that community to follow. Then this is where it leads to a conflict between law and science, because as I told you, law focuses on process and science is concerned with the progress. While both law and science are evidence based systems for finding the truth, the law is concerned with normative considerations such as fairness and justice, considerations generally outside the scientific framework. In the cases of science, the science or the development in the science is not based on fairness or justice. Most legal decision makers, for example legislators, judges and juries, have very little scientific training and expertise, and yet are called upon to decide highly complex technological matters. So, this is what leads to complexities or conflicts in the harmonious relationship of law, science and technology, and that harmony never comes because of so great and contrasting differences. So, there is therefore concern that legal decision makers will fail to reach scientifically credible decisions and will be improperly misled by junk science. The result is that amateurs end up deciding cases argued by experts, and it leads to injustice, and it leads to failure of the purpose of law. So, this conflict is ongoing, or is nemesis, and it has no answer, because both fields are equally important, but are different, are based or premised on different considerations. The legal systems has instituted a number of procedural and substantive innovations in an attempt to enhance the scientific merits and credibility of its decisions. One such innovation is the use of neutral or third party experts. So, the courtrooms these days invite the third party experts to comment or to give their expert opinion on a particular subject matter pertaining to science, or necessarily involving science. So, in the legislative context, there is a growing recognition of the need for legislature to have their own scientific and technological advisory bodies, which is one problem, that the lawyers or the judges etc., they do not have their own scientific and technological advisory bodies. They invite experts, and they run or the trial or the process of the court is being run on the basis of the expert opinions. When it comes to their standards, or the contrast between the standards, then there is an area of dispute, which is whether the law should apply scientific standards and methods of proof, or apply its own standards to scientific evidence. Science and technology are processing at increasing rates. The law is much slower to evolve, with case law advancing incrementally and gradually, and legislation advancing only sporadically. So, this is a very important statement for you, or this is a very important point for you to notice, that law advances incrementally and gradually, unlike science, and legislation advances sporadically. Rarely there comes legislation catering to the science. Statutes in particular can quickly become outdated, as legislatures are limited as a practical matter to revisiting most issues every few years at best, and for some issues every few decades. So, the result is that the law is often based on outdated scientific assumptions or fails to adapt to new technologies or scientific knowledge, and which is why all the chaos. So, this slow or snail paced law making cannot cope up with the fast and meteoric scientific developments which are taking place in the society, and we have seen that their standards are totally different, their premises on which they are based are totally different, they are they are different disciplines altogether, yet there is a confluence of both, and yet that is required and imperative, but there may be some solutions, or you may say some interventions to have a harmony of both. So, to conclude, I will say that law basically interacts with the science and tech in diverse ways, and these interactions will proliferate in the future with advancing law, with advancing technologies. The nascent legal field of law, science and tech seeks to provide a systematic treatment to these actions, and will grow and evolve in parallel and with its subject matter. It is a legitimate task of the law to consider the social merits and demerits of scientific or other development and regulate human conduct. It is a task of law to guide and shape the world, and to deal with the dynamics of technical developments and their effect on human beings. So, to conclude, I will say that with this course, the idea of bringing this course or to teach this course is to make the world understand that there may be some set of laws and there are some set of laws which are catering to some scientific and technological developments or innovations in a very efficient way, as well as to basically propose that law should strive constantly strive to deal with the dynamics of technical developments and their effects on human beings, and it must not stop by just sitting complacent. And so is the responsibility of the scientific community to abide by the law and not to transgress or intrude into the legislative sphere, but rather to abide or do their scientific research in consonance with the laws or in consonance with the regulations. So, thank you very much viewers for listening patiently. I will come up with more such interesting lectures in this series, wherein you will see the intersection of specific technologies with the law. Thank you very much.